BioStrategy Partners is a nonprofit consortium of academic medical centers and academic institutions, and it is committed to the transfer of academic ideas into the marketplace. So I'd like to take the time to thank our sponsors for making this event possible. That includes MBM Associates, Caesar Revise Intellectual Property Law Firm, and University Place Associates, which is where we are today. So I am very thankful for having this fantastic space. So I would like to turn it over to our guests today, and I would like to point out that there is a chat feature in our webinar. So if you have questions, please submit them there, and I will forward them to our speakers, and we'll do our best to address them. Great.
Hello, good afternoon. My name is Joseph Devine. I'm an attorney with the firm Spector, Gadd, Rosen, and Vinci, headquartered here in Philadelphia. And I am a corporate or business transactional practitioner, handling business matters in a general sense, from corporate formation through mergers and acquisitions, capital formation, various financing transactions, and just general corporate work in a broad sense, acting as GC for many of my clients, outside GC, I should say. I've been practicing for roughly 31 years, and I'm happy to be here.
Thank you, Joe. Harvey Hoffman. I am a reformed founder and business owner of several ventures here in the Philadelphia region. Currently, I spend the majority of my time as a mentor, advisor, board member, and investor in early stage and emerging companies. I'm involved with several venture groups here in the region, Mid-Atlantic Diamond Ventures, also Ben Franklin Technology Partners, and work in the mentoring program that is sponsored by PACT here in Philadelphia.
Hi, good afternoon. I'm Joe Murphy. I'd like to thank BioStrategy Partners and Joe and Harvey today. It's nice to be on the panel, nice to be speaking with everyone. I'm a intellectual property attorney. Mainly I handle patent work, but other things as well. I'm at the law firm of Caesar Revise. We're over on Market Street, so we're local. So my background is in biotech. I went to St. Joe's undergrad. I got my PhD at the University of Virginia. And then I was a patent examiner for 6 years. And while I was there, I went to law school at GW. So I've been practicing now for 14 years or so, really handling in the area of pharmaceutical and biotech. And it's nice to be here today, and I'm looking forward to our conversation.
Okay then, so we'll kick it off. As Megan pointed out, today's topic is with respect to company formation, avoiding key mistakes, and reducing costs and structuring for growth. We've broken this out into essentially 9 areas to talk about. And in the interest of time, we won't be able to delve too deeply into each area, but the hope is that we'll be able to get through everything and touch on, even at a high level, some of the key decision-making that has to go on and the benefits and detriments, if you will, to making incorrect decisions or not paying attention, if you will, to certain things. And while maybe a little bit of self-promotion, it's worth pointing out that with respect to this whole area of company formation, the earlier that you engage attorneys, I think better off one is in handling some of the decision making and structuring decisions. It's the penny wise and dollar foolish kind of principle. So that said, we'll simply go in order, but we may jump around a little bit as well. So the first topic in logical order deals with formation. And when we talk about formation, it essentially boils down to several, if not only a couple of choices, right? You have typical traditional C corporation or corporation that everybody's familiar with, been around forever, hundreds of years. And the other alternative, for the most part, is a newer hybrid, if you will, which is familiar now to many because they've been around for, I guess, 20 years or so, give or take, limited liability company. There are other choices, partnerships, general partnerships, limited partnerships, but I think when you're talking about essentially starting a business, you're going to be faced with those two alternatives. Do you agree, Harvey?
Yeah, I think that what I see in the early stage community is the decision that you're talking about, which is, do I do an LLC? Do I do a more traditional corporation, whether it's set up as a C or subchapter S? But one thing that's important is many companies will do the basic online incorporation.
Right.
You know, I always recommend to companies that they seek legal advice. I can't speak across the country, but here in the Philadelphia area, every major law firm has what they will call an emerging growth practice or something similar. And most of those firms are willing to spend a little bit of time giving you some advice and even helping you do the initial formation. In the end, though, what you form at first is always subject to change. You know, I've seen many companies go from LLC to reincorporating in Delaware as C corps. Typically, that is often pushed along based on the stage that they're at.
Right.
And a lot of those decisions and changes also come along when you get your first round of institutional investment or angel investment.
And actually, that's a good point, because as you evolve in time and in development, reaching out to other investors, that can sometimes drive you into a different form. But even still, when you're thinking early, the very initial stages, the one point I will make, I think, even though I'm not a tax practitioner, is that converting from an LLC to a C corp is a bit easier than going from a C corp to an LLC. I don't think you'd see much migration from C to LLC.
You rarely see
Yeah.
anything going from a
Right.
full corporation back to a limited liability
Right.
corporation.
Right.
Typically, companies are going to that more structured environment because there are things that impact the way investments are done. Although I will tell you, contrary to lots of bad advice out there or contradictory advice out there, you can do investment under an LLC. It just takes a slightly different form than if you're doing straight up equity or common equity under a C.
And I guess it's important for the audience to just make note of the fact that that one of the primary differences between the LLC and the C corp really involves taxation, right? Because with the C corporation, you have what's called a dual taxation in the sense that the earnings of the company are taxed at the company level, and then if any distributions or dividends are paid out from the company, they'll be taxed at the individual shareholder level. And so you have a combined tax there that historically has been very high at times. It has come down in recent years, past couple of years with the Trump administration, and has actually made C corps a bit more palatable in that sense. Whereas with LLCs, you have essentially the tax treatment that you would have by default with a partnership, right? Where the IRS doesn't look to the entity for collection of taxation, but looks to the flow through to the individual equity owners or members of the LLC for paying taxes on a flow-through basis. And so that's a huge distinction and is a big driver in terms of the early decision making. Because in many cases, the founders may want to start out looking more like a partnership, I think. Recognizing that down the road, they may, as they look for funding through institutional investors, they typically want to see a C corporation, I think.
I would say that's typical, especially as you get beyond seed and you get into Series A.
Right.
But again, I have seen companies that have maintained an LLC structure
Yeah.
all the way through.
Yeah.
Again, it gets a little more complicated, but nonetheless,
No,
it can be done.
And that's a good point in the sense that there isn't one right or wrong answer to any of this. If there was, there would only be one choice, right? So it's important, I think, to highlight that it's a very facts and circumstances, kind of who your audience is, what your interests are from the get-go. But they are the I guess the important considerations to take into account. There are also some employee compensation issues that one might want to factor in, which we'll talk about a little bit later on. But we might want to move
It's also
on.
it also involves the founder or partner compensation, the member compensation.
Right.
Is different when you're in an LLC and then when you take on investment, as opposed to a C corp. Because technically you can't be an employee of your own LLC.
Correct. Unless you have if you do an S election, you might be able to. But again, I don't intrude in the tax realm too
I
much.
stay away from taxes.
Yeah, I
That's
got you.
why there's professionals.
Okay, so I think we can move on to the next topic, which is clearing and protecting use of brand names, logos, domain names before creating value in them. So when you think of brand names and logos and whatnot, you're thinking of your identification of you, your business, you, your products, you, your services, and how you identify them to the public. And it's important, fundamentally important, to, in my experience, to do some due diligence up front, so that once you start down the road with a name, with a logo, with some identifier, you're not going to be unpleasantly surprised to find that somebody else is already trading in a similar area of business with that name, logo, what have you.
I think, if I'm,
Yeah, Joe.
I think with trademarks and trade names and such, it is important to clear it as well as you can up front. You want to be careful that you don't accidentally, disparage or dilute a famous mark. Some of these famous marks tend to be very aggressive when they're protecting their mark. That's part of the responsibility one has as a trademark owner. So it's like Joe had mentioned earlier. It's good to get your counsel involved early. Let them know what you're thinking about calling your company, or how you're going to brand it, or how you're going to brand your products or whatever, your services, however you're going to do it. To get an idea of whether you have freedom in that space. It would be called a clearance search, usually in the trademark space. And then, in order to protect it, there are common law rights that arise as soon as one uses a trademark. They're somewhat limited. So, if you want to pursue like a federal registration, there's a couple different ways you can do it. You can either do it as if you're actually using it, you can file it's already in use, a 1A application, or you can file what's called an intent to use application. That can, you can go through the process of the trademark prosecution process to the point where you get your notice of allowance, hopefully, and then when you get it used, you can file a statement of use, and you'll have it. And that shows that you have ownership of it, and it gets rid of a lot of the problems that arise if you're trying to force a common law trademark.
Yeah. So, go ahead. No.
Joe, I want to just ask you a question or clarify something. The difference between a corporate name and a mark or a logo.
Right.
There are times where you can get a logo trademark,
Right.
but you can't necessarily get a corporate
Corporate
name
Right, that's
trademark because
Yes.
it's much more common, whereas the mark itself gives you a broader
Yeah.
capacity to get it marked.
I think it kind of depends. You want to use it in the context of either goods or services. So you're providing a service, say, and maybe that's what you call your company. Like, if I was actually just looking at Apple's registration. And it goes on for like 2 or 3 pages of all the things that they can provide.
Right.
So you have to use it in conjunction with your goods and services. So really, you want to brand your products or your service with your name so that you can get it registered like that.
Yeah, and so there's two facets to this. The one facet is doing, from my experience, doing some due diligence to make sure you're not crossing into someone else's territory and going to get hit with a cease and desist letter,
Right.
if you will. But then there's also the component of once you do clear it, you have something you like, and that you're going to invest in and create value in, because that's what this is all about, right? This is creating an asset, really. The asset's called goodwill on the balance sheet, which is an intangible asset, which can be very valuable over time. The Apple's a great example.
Right.
But taking some steps to protect as well your choice once you've gotten all the clearances. So as you alluded to, filing the intent to use application with the trademark office is a way to get that registration going sooner rather than later before
Right.
you're actually using it, right?
Right.
And getting the protection afforded by the registration on a national level.
Yep.
Even though you don't have to register, right, Joe? Because you
You-
can have a common law
Absolutely.
trademark.
Right. But then a lot of times you run into issues where you're just sort of geographically located or
Right.
limited, that kind of thing.
Right.
Where, like as you mentioned, if you get a federal registration, you're covered in the country. You don't have to really fight about who owns the mark and that kind of thing,
That's
and where the boundary law lines are as to who should
Right.
own that kind of mark. And
Right.
honestly, the best thing to do, Acura, Lexus, things like that. So just made up words. That's
Sure.
that's the best kind of
The
marketing.
more
you can have.
arbitrary, the better. Right?
Absolutely, yeah.
Google.
Right. Right. You call it Joe's Pizza or something like that, you might have trouble getting a national registration for it. You make up a word, you're going to have a better chance.
Right.
Joe,
And
where does international come into this? Because that comes up,
Right.
often with companies that are starting here, but everybody thinks
Yeah.
international.
Well, you can actually use, even if like Joe and I were talking about, say you're starting a new company and you come up with this name, you think it's clear, you want to get an application on file, so you file an intent to use with the U.S. Patent Trademark Office. You can actually use that as a basis for an international filing.
But
So,
it is a separate filing.
It's a separate filing. It's called there's ways you can do it, but the easiest way is probably the Madrid Protocol. That's sort of a common law, sort of a common application way that you can file in multiple different countries, all at the same time. It opens you up to certain sort of central attacks, which but that's probably the easiest way to pursue international coverage.
And I will briefly just point out, I do find with clients a lot of times there's a little bit of confusion between reserving a name, if you will, for my entity, whether it's an LLC or whether it's a C corp when you form, versus what we're talking about. Because the name of the entity in and of itself, you do need to check availability sometimes, because if it's confusingly similar, the Secretary of State's office may bounce the filing if it's too confusingly similar.
Right.
But the name you're filing with your charter or with your articles of formation, forming the entity, is really like your it identifies with your legal name, if you will. It's nothing really more than that.
Right.
So I sometimes find myself having to distinguish, so clients appreciate. This, I think, is much more valuable than what we're talking about here.
Right.
And then I guess the last thing to point on and touch on in this area has to do with domain name registration. I think is worth mentioning, simply because I think it can get overlooked. I have found it overlooked at times. I had one circumstance where the client, we talked about it, I was told we're taking care of it. A year later, finding out that nobody, when I raised it, for whatever reason it was, found out that the principal I was dealing with drew a blank. Didn't know who, if anybody, was taking care of that. Went to check on it, and it was not available. And but then we had a nice ending in the sense that it was a relative who had, in talking with the client a couple of years prior, had gone ahead and reserved it. So, but the domain name can be one of those things where it's very easy to get a reservation on a domain name, but it's also very easy to kind of let slip through the cracks, and then becomes more of a problem because there's a lot of accumulators out there who grab them for purposes of resale.
I can tell you, I mean, in practice, you'll often find domain name much harder to register than corporate name or logo. Because not only of squatters and people that have registered lots of them, but also because of the commonality. But there's typically ways of getting around that
Finesse.
with a hyphen, an underscore, and of
That's
course,
true.
and of course today with all of the higher domains such as .net and .go and .com, you know, there's ways of getting around it, you know, and then you've got the typical ways of joesllc.com, and
Right.
those all become opportunities. But in practice, I often find that domain names are actually harder to grab and register sometimes than the corporate names themselves.
Right. Okay. So next topic then. We have clearly agree on and properly document founders' roles and responsibilities. I think the word of advice here is that we're talking about the formation stage of evolution. We're really talking about the founders who are coming together to start the venture, and maybe some very early seed investors. But the important point here is that I have, in my experience, and Harvey certainly chimed in, is that this is a stage where it's seductive and to take things very informally and be comfortable because of the relationships involved and maybe not wanting to be overly formal, if you will, at that stage. But the word of caution is that is not to avoid clearly setting up the parameters of ownership, management, decision making at a high level, if you will, because as time goes on, without having things properly memorialized, that's where you get involved in disputes sometimes that don't always work out in a favorable way. So I just find
Well
that
said, actually. Yes.
I just find it, even though it can be hard to kind of impose formality at the very early stage, it's worthwhile, and I'd be curious to get your view on that.
In reality, you know, these things typically or very often get overlooked or kind of boilerplated at the time of the formation of the company.
Right.
But operating agreements become really critical when you start to talk to investors, because that really guides the operation of the company.
Right.
And of course, any fundraising effort or things such as that wind up having to become part of that operating agreement, and operating agreements are constantly being revised with companies that are at that stage. So I'm curious, does the operating agreement have any impact on the patent or IP area?
I mean, I think it can, you know, whatever is included in the operating agreement, I think, however they're going to slice it up. And
Well, I think what I don't know if it's strictly the operating agreement, but what comes to mind for me is that with respect to any IP that's coming in to the organization, particularly that's being contributed by founders, that making sure that that's properly documented, identified, memorialized,
Right.
if you will, so there's no confusion
yeah, I
as
think
to who owns what, if you will.
I think we'll probably get to it in a moment, but you know, patents are owned by their inventors until they're assigned to someone. So you want to make sure, and as part of the operating agreement, it might be that if you're going to be a member of this LLC or whatever, you know, you have to sign all your patent rights or IP rights over to the LLC, something like that. I mean,
Right.
that's where it might come in.
We do have a comment from the audience, and they're wondering what your comments are on the fact that universities often restrict the role of inventor founders in the management of new companies.
Yes, I have. I actually have experience with this. I've dealt with several tech transfer deals with different universities universities. And in fact, Joe and I are working on one together right now, where it is common, and this is we could have a whole program on this, right? But I'll just, I guess, cut to the chase in that the professors or the scientists who are getting involved on the venture side, they're subject to a lot of policies, and that the university or any other sponsoring institute will impose. And many times they do go towards the involvement of that scientist, doctor, or professor, etc., in the venture. Many times what we end up having is a consulting arrangement of sorts that is very contained and restrictive in the sense that it doesn't overly commit that individual to the venture, but the venture is getting some benefit, if you will, with input. But usually, stock ownership is, there are usually policies around how much stock can be had percentage-wise, whether it's below control levels, minority levels, small minority levels. It varies from university and institution to institution. And certainly, I would say by and large, there would be prohibitions on being on the board of directors, being an executive officer, or even an officer for that matter, of the organization. But again, usually the way of sort of accommodating everybody is through some kind of a consulting arrangement.
I don't think that I've seen a lot of restrictions at the university level that are not more fundamental. I mean, the biggest issue typically is that licensing agreement for the technology that's being developed
So that's right.
at the university, which typically is the fundamental foot or
Right.
basis for the ventures that are being developed. Certainly, there are restrictions about for tenured professors and other people, and that's university to university, and a lot of times that might create some management restrictions when in the development of the venture itself. But licensing agreements can also drive that. I've seen that a lot with a licensing negotiation of that licensing agreement.
Oh, absolutely. No,
really
certainly.
drives those kinds of
Yeah,
decisions, and
yeah.
where the university really gets involved in that negotiation.
I agree. I agree. The licensing of the IP is integral, if you will, to the whole spin-off. I think it's just, and to tie that together, if you will, it's kind of sometimes depends on where the IP is in stage, and the professor or the scientist who's involved in that IP development. That's where there can be some of these stronger policies that come into play in the active role of that individual on the commercialization side. So, hope that addresses the question. So then, back on topic then, with respect to documentation and roles and responsibilities, is there anything else we want to chat on? Where the documentation comes into play for addressing ownership rights, management, decision making, and the like. We're talking about either the corporate side shareholders agreement that will essentially tailor provisions, or the operating agreement in the case of the LLC. I liken those documents as like partnership agreements, if you will. They are the tailored arrangements among the stakeholders in the venture that in many cases will override, where permitted, what's by default under law. So that's another highlight, I guess, to make, which is why you should pay attention to this topic and addressing these issues, because if you don't, there's a statute that will fill in the blank. In many cases, not always, but which you may not be happy with. So, setting out your arrangement with your co-founders is prudent, I think.
I just want to touch on one thing, and it's simply that an operating agreement is not set in stone. I alluded to it earlier with
Right.
subsequent events, but
Right.
you know, I think people may shy away from doing a proper agreement because they think somehow that's going to create a problem going forward, and in fact, it's anything but. The
No, it
operating
should be a
agreement,
living, breathing
it is a
document.
living and will change over time and can change over time as
That's right.
as the venture changes.
Yeah. And the other thing that comes to mind too is one of the reasons it's good to pay attention is inevitably there will be some friction at some point, and this is a good place to address how the friction is resolved. And so some form of dispute resolution mechanism should be spelled out. I think it's always a good thing. And I also find an important topic to address is if somebody's leaving, they want out. Have you thought about what the rights are in those circumstances? Because I think it's good to give some thought and to address that up front rather than face it down the road and have to sort of work it out, if you will. And there are many ways of going about that. So I guess we can move on to the next topic, which, Joe, is near and dear to your heart. Developing and implementing a comprehensive IP strategy to ensure that the company has and retains essential IP rights. Since a lot of startups involve technology and IP,
Right.
you can't talk about this subject matter without really having a full discussion on IP. I think.
Well, so with regards to IP, I like to think about it in two types, right? I think there's the internal intellectual property that's being generated by the founders and the members, and then there's also considerations of the external stuff. So you've got the internal considerations versus external considerations. So just to start out with some of the internal considerations, and we were talking about operating agreements and things like that. And I'd mentioned earlier that at least in patents, the inventor is the owner of the patent off the bat. So when you have a company or corporation or whatever it's going to be, whatever kind of entity you're setting up, you want to make sure that you have your employees under agreement. You want a strong employee agreement so that it's clear to them that they have to sign the rights to the business entity. Then there's other considerations that come into place too. You have to set forth for them that they have to maintain like lab notebooks and things like that. They have the responsibility to quickly disclose whenever they develop any IP to the let's call it company. One other wrinkle in this is if you're dealing with universities and companies spinning off from universities, if you've got any kind of federal money, you might fall under the Bayh-Dole Act. Very likely do fall under the Bayh-Dole Act, and there are certain very stringent requirements under the Bayh-Dole Act about what employee agreements look like, how the rights in the IP are allocated and things like that, and can really affect your rights. It's the law's recently changed. It's become a lot harsher. We don't have to go into that, but that's one thing to keep in mind. Other things to think about. A lot of companies now, as part of the employment agreement, a lot of companies now have this sort of bring your own device kind of situation. So one thing to think about in the employee agreement is, what are the rules governing the use of your own iPhone or whatever?
Right.
Remember, we'll get into reasons why, but you have to keep all this information confidential. Can you put it on your iPhone? The question is it still confidential if it's on your iPhone? You need to have a way to pull it back off your employee's iPhone if they quit, that kind of thing. Another thing to think about is social media accounts that you can have that can affect your IP. Who owns that? You have your employees set up a LinkedIn account. Is it their personal LinkedIn account, or is it you're owning the LinkedIn account? So when they quit, it comes back to you. So these are the things to think about in the employment agreement. So as far as IP generally, I mean, maybe I could just go through briefly to set it out for people familiar with these things. I think the big one obviously is patents. We discussed trademarks, right? So
I think we covered
we covered pretty well. So we'll jump to patents. So what is a patent? Patent covers process, manufacture, compositions of matter, machines, anything made by man, things like that. And patents are interesting because if you ever open up a patent, I don't have one here, but at the back is a claim set. So you can think of the claim set as being analogous to the boundary lines of a piece of real property, like defines what the invention is going to be. And a patent is a quid pro quo, this for that with the government. And part of what you get is a 20-year from the date of earliest filing for the patent term, and it's adjustable in certain situations. But as part of that, you have to meet certain requirements, right? You have to set forth disclosure that enables one of skill in the art to make and use it or practice it. You have to have a complete written description of the invention, and there are legal issues with all of these, especially in the areas of biotech. The first one that has recently come under a lot of strain is this patentable subject matter. In the areas of biotech, computer-implemented inventions, and especially like medical diagnostics, has become real difficult as to what is and is not patentable subject matter. So that's something you have to keep in mind. And then your claims have to be definite. So one of the things to keep in mind about patents, and we mentioned international rights with regard to trademarks, so I'll say this briefly about patents. The key to it is to keep everything secret until the application is on file, right? So I've mentioned employee agreements. Part of that will be confidentiality. If you're going to be talking with potential consultants or anything like that, you want to have non-disclosure agreements in place to keep everything confidential. What's the problem if you have an accidental disclosure, so it's no longer confidential? Someone gives a poster presentation or something like that. Right. In the U.S., there still exists sort of a 1-year grace period, but it's more limited than it used to be. So if an inventor or someone who derived it from the inventor discloses it, you have like a 1 year, you can still file in the U.S. an application. The problem comes if you want to file for international protection. A lot of countries, we're now a first inventor to file country, but it's sort of mixed. A lot of countries are like absolute first to file countries. So that means if there's even a slight disclosure, you have cut off your rights to file in that country. And there are certain exceptions, but generally speaking, if you have an early disclosure before your application's on file, you might be precluded from getting international patent protection. How do you prevent that? You can make use of something called provisional applications. So provisional application is a way to sort of get an early filing date. You have to be careful though. You still have to meet all the sort of written description and enablement requirements that you would in the regular utility application. But that gets you a priority date locked in. You have a year in order to file either a utility and or an international application. So sometimes we tell clients to in situations where the client is still developing their technology, but they want to get something on file, so we'll file an early provisional for them. But then you can make use of this thing we call it rolling provisional strategy, right? So let's say you're claiming a formulation or something like that. You get your initial formulation on file. As you develop it further during that year, you can get other ones on file. Eventually, at the 1 year deadline, you would file your U.S. utility and or your international application, called a PCT application. So that's a good way to go about it.
Joe, let me ask
Sure.
you a question
Jump in.
about engaging with the patent office.
Right.
Okay. And what's the process? You talked about you want to get it done earlier than
Right.
later, but what's sort of the process? There's also, I've come across these situations where you can talk to the patent office
Right.
and get feedback, although you don't really have a registration yet.
Well,
So, I mean,
right, with a patent, what I mentioned earlier with a provisional patent application, that's not examined. So when you file what's called a utility application, that's in the U.S., that's what could eventually issue as a patent.
Right.
You go through a prosecution in front of the Patent Trademark Office. So you'll deal with a patent examiner, and they'll give you, you'll send in your application and say, all right, this is my claim set, and they might restrict it down and say you've got more than one invention here, so you've got to pick this invention, we're going to examine it. So you pick your invention, then they give you an office action, and they'll say, okay, these are the reasons why, and a lot of times it comes down to you need an invention. It's got to be patentable subject matter. It's got to be enabled, written description requirements, right? So it's sort of formal requirements, and then you've got the art requirements, right? It's got to be novel and not obvious. So if the patent examiner finds one reference that she feels anticipates your claims, then it lacks novelty. If they combine two or more, then they say that's obvious, and then you have a chance to go back and fight that.
Right.
And there's, you can amend your claims, you can put in new evidence to say, oh no, we have an unexpected benefit, things like that. But that can be extended, especially in the areas of biotech or pharmaceuticals or computer implemented inventions, things like that. I mean, the prosecution can go on for quite a while.
Isn't there an inquiry only path with the patent office?
So
as far as I'm thinking about filing this, is there a way, can you engage with the patent office before you actually file?
Not per se, no. What some people will do, sometimes people will file. You can do this with a PCT. It's an international application. You file it under the Patent Cooperation Treaty called a PCT. You can actually file that, and just after you file it, like 4 months later, you get a search report. So that's and depending on what search authority you use, that'll be their opinion on, if you're free of the art or not. But there's no way to engage with the U.S. Patent Office. You can file applications and say, and there's certain programs you can go through where you'll get an earlier examination or something like that. But that's an examination. Like you're on the clock for that. So.
Joe, I'm curious. Is there any interplay with trade secret protection and patent protection in the sense of there's some rationale to maintaining something as a trade secret
Right.
for a period of time before going after the patent, or is
Yeah.
it always just rush to the patent?
So trade secrets are interesting, and they are very useful. So trade secret is something that has economic value to the company, and part of that is that its economic value comes from it being a secret, and also you have to protect the secret, which I'm sure you're aware of. Take reasonable efforts to protect the secret. So how that interacts with the patent system, and I think for a company, especially in a situation where you're performing a process, always consider trade secret because especially because it can be difficult to get a patent on a process where, like I've seen situations where a temperature difference is very narrow and a process works real great. There's one very specific temperature, but varied a little bit, it won't work at all, or it doesn't work at all. You try to get that in front of a patent examiner, they're going to say, oh, that's just routine optimization, and you'll never get a patent on it, or else it's going to just be a real struggle. So that's the kind of thing that you would want to keep as a trade secret.
Right.
The weakness, of course, is with the trade secret is that really it's enforceable against your employees, your former employees, your consultants, people who have a confidential agreement in place with your company. People develop it independently. You can't go after them for anything unless someone has abrogated their rights and they've misappropriated in some fashion. So,
Right.
but that's how I think about trade secrets. Yeah.
Good. And you touched on agreements for protection in terms of confidential information, trade secret protection, and your employees. I find it's really advisable, because these are pre-template oriented agreements that you can easily put together and have in a standard form, and always advise companies that these are documents that get signed at the initiation of employment. Because if you enter any kind of, in addition to this confidentiality, non-disclosure components, if you inject any other protective type of covenants, such as non-solicitation, non-competes, that sort of thing, you really need to have some teeth, enforceable teeth to the agreement, and having it done at the inception, the offer of employment is made, is valid consideration in most jurisdictions, certainly Pennsylvania, to give the enforceability there. So I think it's prudent to have those forms at the ready and as a matter of course, just sign. There's also the component of the IP side with respect to any developments by the employee, that there's an acknowledgement of assignment, that their company, works made for hire, etc., that are
Right.
that are owned by and property of the employer, not their individual
Right.
ownership, which I think is important to have documented as well.
Yeah, absolutely.
Okay, if there's nothing else on this, go on.
I might say I might throw out one more thing to keep in mind for people, and this, I'm gonna touch on copyright. We haven't really mentioned copyright at all.
Right.
And just very briefly, copyright covers any works of authorship in a tangible medium.
By the way, if I could just plant a seed too,
Sure.
I get a lot of questions from clients that, with respect to software,
Yes.
like what kind of protection, IP protection is in software.
Right.
That,
Well, software can be very difficult. As I mentioned, that's one of the areas that computer implemented inventions and software kind of issues that come up, whether or not it's patentable subject matter with regard to the trying to get a patent to issue. So that's one. And there are other ways you can protect software. Like say you've got an app and it's got the little icons. You can get like design patents for those. You can copyright those as well. That kind of thing. Sometimes you can get other kinds of protection for the look of it. But I'm gonna throw out a danger that arises with software
Right.
specifically.
okay.
So what a lot of people do if they're coding, and I'm not, my background's in biotech, so I don't know much about coding, but my understanding is that when people are given a task to come up with a program to do something, a lot of times you go up online and you'll find, oh, somebody wrote this code, I'm going to throw it in my code, I'll take this one, I'll throw it in here. You have to be very careful with that because a lot of that stuff is covered under what's called a Creative Commons license. And anytime you take something that's covered by a Creative Commons license and you put it into your product, you were now made a derivative work, and it will theoretically be covered by that Creative Commons license. So you have lost theoretically the right to get a copyright in it. So you have to be very careful when you're going to be pulling stuff off the internet, code, pictures, language from Wikipedia, whatever it's going to be. So that's one thing to keep in mind.
That's good. That's good to know.
Yeah, I mean, I can tell you that in the real world, at least what I see today is very little protection being undertaken by tech and software firms. For a couple of reasons that we've mentioned, one of which is because they want to stay dark until they launch. They don't want to disclose any of that. But also because of the difficult issues around getting protection for software and the amount of money that an early stage company may have to put into that legal work. And for the most part, investors have come to the place where they accept the fact that it's not patented and it's not protected other than by trade secret.
Right.
And
Perfect.
so the critical thing is what do you really have in trade secret that is really unique to the product or your venture? And is that distinguishable enough that in essence it creates its own protection?
Okay, good. All right, then, with that, we can move on. complying with securities laws, always a fun topic when raising capital. This is a topic or an area that I have been involved in quite extensively over the years. In this context, it kind of does boil down, I find, to a pretty narrow focus from a regulatory perspective. Whether you're raising capital at the seed stage, or with angel, or early venture capital, all the way up through series, later series rounds, preferred, etc. With venture capital and private equity, without getting into a tutorial over the securities laws, you have to comply with the offer to sell security, the federal and state laws, and by and large, in this realm, you want to avoid something called registration, because that's the public company arena. That's when you go into IPO, and that's a whole different ball of wax, right? Not to mention a lot of resources coming into play, so which blow this stage out of the water when it comes to raising capital. So, the SEC over the years and legislation over the years has tried to accommodate capital formation at the small business startup stage, and so and has worked on regulations which provide for exemption from that registration process. And in this realm, that exemption comes down to what is common parlance, or commonly known as Reg D, private placements, and what we're talking about is really identifying sophisticated high net worth type investors who can afford the risk and the risk of loss of investment at this stage of a company's development. And the accredited investor is the definition of that type of sophisticated investor that one wants to identify in conducting a private placement. So, in your experience, have you seen much in the way of venturing outside of that realm?
Personally, I'm not sure what you mean by outside the realm, but at the earliest stages, you've got what people always talk about is friends and family.
Right.
And that's typically friends, family, extended. They may or may not be accredited investors, but and a lot of times that's coming in as common or as some sort of a loan or convertible debt.
Yeah.
You don't really see much issue there. When you get into a seed or a Series A round where you're starting to really engage with angels, private offices, other individual investors, obviously the materials that you use to put forth need to get reviewed properly through legal counsel.
Right.
And at the close of the round, then there is a filing that has to be made with the SEC just to basically list the fact that you've raised the capital. The issues really become when you move up, and then it becomes much more difficult, or there's more legal issues involved. When you're starting to branch out, you're starting to talk to more than a handful of investors. I don't claim to know what the laws are, but I know you wind up touching all of these different levels.
Well, I asked the
different
question
laws.
the way I did because you've highlighted on some of the things that I want to kind of bring up, which is at the very early stage, when we're talking about the founder group, that's usually because that's a group coming together. That is the one area where you don't really fuss too much at all, because that doesn't constitute, if you will, an offer and sale by your organization, that is the formation of the organization. It's only after that stage, but it can be friends and family, right? And that tends to somewhat be handled fairly informally, and casually.
Or rarely handled.
And casually, which, maybe 9 times out of 10 will be fine at the end of the day. And you may not run through all the hoops on the regulatory side to document it as a Reg D safe harbor private placement, and you may not file your Form D with the SEC, which is the notice filing, to take advantage of that safe harbor. But nonetheless, I think working in conjunction with an attorney, at least being cognizant of what some of the elements that are important to be satisfying when you're reaching out for investors, even at that early stage, is important. Why? Because if you do trip up and you don't comply with some of the key components, what you end up doing is possibly suscepting the organization to, when it comes time down the road to approach a more sophisticated investor, they're doing their due diligence. They're looking at what's been going on. They may or may not raise issues with how you prior raised capital and whether or not you were compliant or not. And because of that, you put yourself in a difficult spot sometimes.
As long as the first round or the friends and family are quiet, it's typically not a problem.
Typically not.
But I certainly have seen situations where founders have brought in several convertible types of debt instruments or straight up debt, and they've sort of rolled them along for the first year or two, and now some of those unsophisticated investors start to ask about, well, when do I get my money back? Because they didn't really understand that, although it was technically a loan, that rarely do those loans get paid back until some other event takes place. And that makes it then much more difficult for the institutional investor in that early round to actually grapple with the issues that the company is facing, and can often really actually kill an investment potentially.
Right.
And so even if it's friends and family, to your point, make sure it's documented, make sure you have loan agreements or convertible debt agreements or whatever it is, make sure that you've got them so that, if anybody starts to raise a problem, you're covered.
Right.
Okay?
Yeah, because the problem is potentially a practical one, but there's also a harder element legally, in the sense that the institutional investors all know this, that if there is a fundamental problem with a prior offering of any sort, they're cognizant of the fact that there's something called a rescission right, that those prior investors might be able to say, I want my money back, because of a non-compliance issue. And that is not something a later stage investor wants to deal with or hear about. So, okay, and then there's always, I guess, from a practical point, I would say, and I have this conversation all the time with entrepreneurs and founders, that when you're looking to raise capital, you really need to contain yourself within that accredited investor population, because once you drift out of it, you're putting yourself in a realm that makes compliance very inefficient, because, again, without getting too in the weeds with regulations, when you get outside of the accredited investor population, you've got more disclosure obligations on the federal side, and then on the state side, you've got more potential filing obligations. So the perfect world here to stay within is the Reg D, safe harbor, all accredited investor. Accredited, by the way, is a definition, and it's a very long list of criteria or categories, groups of potential investors, but when it boils down to the practical, we're talking about high net worth individuals, which actually over the years hasn't really gone up any. So now there's plenty more of them than there were whenever this regulation was first put into play 30, 40 years ago, which is net worth of $1 million or more, not including your principal residence, but also excluding any mortgage associated with that. Or you have income of 200,000 or 300 with your spouse for the past 2 years, and an expectation of having the same in the current year. And then there's a whole list of other types of criteria. But the beauty of doing that is you really can tailor your own disclosure and do so in a very, again, tailored fashion to just more or less be prophylactic and protecting the issuer and not worrying about the technical compliance side. And then the other real big benefit is on the state level. All you have to do is file notice filings with the state, as opposed to doing a much more rigorous compliance. So that's always my advice early on with entrepreneurs. And then the last point I'll make on this topic is, in a lot of cases too, I find that there's that enters into discussion is using finders rather than registered broker-dealers. And can I pay somebody who's going to bring an investor to me? They're difficult discussions at times, I find, because clients don't like hearing no. But this is one of the few areas where I almost always say no, because the SEC is extremely strict on requiring anyone who's getting compensated for assisting in raising capital to be registered as a broker-dealer. There's a really narrow exception to it, but it's impractical in application. So I raise this because and I've had occasions where clients still forge ahead, you run the same risks of non-compliance as we already touched on. If you raise capital, you pay somebody, you brought you somebody to make the investment, and they're not registered as a broker-dealer, you open yourself up to rescission rights, non-compliance penalties, etc. So I bring that up because I do find the finder topic comes up time and again. And that's really all I had on that. Otherwise, at this point, I think we're getting a little bit tight on time, I'm seeing. So, labor and employment laws. I think we can go through this somewhat quickly. I am not a labor or employment law practitioner, but there are some things that everybody should know about and be sensitive to, I find, particularly at the early stage, because resources are tight. Entrepreneurs, startups are always looking for efficient, I should say, ways of doing things. And in doing so, I find time and again that there are examples of not paying attention to the employment laws for varying reasons. But suffice it to say, both at the federal and state level, that unless you have individuals who meet an exempt category, which, again, without getting into too much detail, is really like your management level, high income types, or professional level employees, you have to comply with the wage and benefit laws, and they're pretty rigid, strict, and that includes overtime, and you can get into some dicey issues with all of that, because this is a stage where there's a lot of people coming and going, a lot of extra hours being put in, doing things, and people even volunteering their time, if you will. So I think it's a fertile ground for exposure if somebody decides to blow a whistle.
I think that in practice, what you find is a lot of issues surrounding the use of consultants and freelancers
Right.
and non-employee
Right.
staffing.
Yes.
And there are certainly issues, and there are a string of guidelines as to what constitutes an employee and where that line is drawn. I would suggest that the most important thing is to educate yourself as a founder, starting a new company. Make sure you educate yourself within the state where you reside
Yes.
as to what the hourly laws are, what the breaks and lunch requirements are for hourly employees, what constitutes both at the state and the federal level a management employee versus a supervisory employee versus an executive employee.
Right.
All of those carry different issues and
Right.
problems as far as compliance.
Yes.
And so I don't think it's the most critical issue that a founder has to deal with, but certainly take the time to educate yourself.
Yeah.
And do your best to comply.
Because the founders are on the line.
The founders and the owners are on the line. Anybody who signs a paycheck or has control of funds is on the line. So educate yourself, and also make sure you get yourself a really good payroll processor,
And you hit.
because they can provide you
Right.
guidance as well.
We have a question which I think is relevant to this. So, do companies need a formal employee handbook?
You won't. I don't know if you want me to answer that one. My answer is no. You don't need one. There's, as far as I know, there's no legal
No, there's not.
obligation to have one. The purpose of an employee handbook is to define the relationship beyond the employment contract. There's positive and negative here. I tend to stay on the negative side because once you develop an employee handbook and you put it in writing, you need to live to that. There's no wiggle room, okay? And for an early stage company, sometimes that can be a little overwhelming, especially if you start to look at the boilerplate types of employee handbooks. There's a place for it. I certainly would recommend that as an early stage company, you put it further down on your list of important things to do.
Yeah, I would agree with Harvey on that. It's not legally required, and it is it's a facts and circumstances thing where, in some cases you may want to have something put in place earlier than later. Certainly over time, you will want to have some policies put in place, and you can have standalone policies, or you can have them, put together in a handbook. So I agree. And once you do, don't just put it in a drawer and forget about it. That can come back and bite you. But the one thing I will say, though, it isn't necessarily the handbook, but and it gets to what I said earlier, which is it is I think prudent to memorialize anyone that you are bringing on as an employee, what the arrangement is. So and I'm not necessarily talking about the executive level. Even rank and file an offer letter which spells out that it's an offer, that you're an at-will employee. Just some of the key terms is I think smart.
I think the offer letter becomes, at this level, the most important because it defines things like work, time, pays, salaries, hourlies. It will typically provide some indication of time off and other policies like that. So the offer letter, I think, is probably along with the NDA document or non-compete document that goes along with it, those two documents at an early stage, I believe, are really what's most important.
Okay, I agree. And then just real quickly, last on this topic is we probably should move on. Is and Harvey, you alluded to this, that a lot of people like to just say, "Oh, well, these are independent contractors; they're consultants." No, they're not employees; they're independent contractors. And a lot of people grab onto the independent contractor concept. Why? Because it's a perfect world, right? You don't have to worry about all the withholdings, paying taxes, etc. That gets pushed to the independent contractor. The problem sometimes comes into play where if the independent contractor isn't really meeting what the IRS's tests are to be an independent contractor, then you've got they're really viewed as an employee. That's become a problem.
And the biggest issue really, the issue typically comes up in the real world when somebody leaves a company. An
Yep.
independent contractor decides suddenly they're going
Yep.
to try to make a claim for unemployment compensation.
That's exactly right.
I've been through these things over the years and fought some of these battles where the company actually was right and
Okay.
what wasn't in the wrong. But nonetheless, as I said earlier, as a founder, just familiarize yourself with it, with what the laws are, with what the regulations are, and do your best to try to comply.
And again, talking about documentation with independent contractors,
Have a contract.
it is very important to have a contract.
Have a contract.
It doesn't win the day necessarily, but it is helpful, very
It's
helpful,
absolutely.
because it'll spell out the parameters which should line up with what the requirements are. All right. Well, with that, let's move on. Because we're running the risk of not being able to finish this. The next topic is properly structuring equity plans for executives and employees of the company. I'll let you carry
This one's near and dear to my heart. One of the things that is important, I think, for early stage companies who will often use equity in lieu of cash compensation, and whether that's for some employees or it could be part of the compensation
Right.
and the offer that's made to them, whether it's outside consultants who you may offer equity in lieu of services, but also very important, which we didn't really get into, but for advisors and board members to your company that often in early stage companies are compensated through equity arrangements. It's really, when you are putting your company together, I would suggest if that's the path you're going to take, and it's typical of most startups,
Yep.
that part of your legal work, part of what you pay for, is to develop an equity plan,
Right.
both for an internal and for an external, whether that's restricted stock or whether it's appreciation rights or other ways of doing it. And it's important not only because of the legalities, but often companies, and I find this regularly, companies that I meet and get involved with will want to add me as a formal advisor or board member.
Right.
And in truth, I give my time to many companies, but if I get involved and it becomes, a portfolio company, so to speak, the expectation is some minimum level of equity compensation for me to participate with the future of the company. If you don't have those documents in place, if you haven't built an employee stock or some stock ownership plan, not employee stock ownership plan, you risk the chance that you're going to lose the input from your advisor, because if you make an offer to an advisor, then you need to live up to it. Don't tell an advisor or a board member, well, it's coming, we've got to put the documents together, we've got to do this. No, it's just one of those things that, since it becomes a regular piece of building your company, I really recommend that you do it early and you set up the plans early. And so if you bring somebody on, whether it's an employee and you pay them X dollars in compensation and potentially 2% or 1% of a company, or it's an advisor, you have an advisory agreement for the services of the advisor, and then you have a compensation agreement, which is the equity part. Get those things done early on. Don't put yourself in a position where you can't attract the best talent that you have, and typically equity is the way in which you attract the very best talent that you've got.
That's good advice. Yeah, and I think along with early is kind of working with somebody to kind of properly plan it too, because I think some components of incentive comp on the equity side play a better role earlier on than later on, as opposed to others. Because and being mindful of what type of incentive compensation makes sense at what stage, if you will.
Correct.
Because early or very early on, where the value of the enterprise is low, restricted stock might make a lot of sense.
Sure.
Right? Whereas later on, when there's value been built up, then restricted stock.
Well, but now you talk more about options
Now you're
program,
talking options,
different
right.
kinds of options arrangements, and
highlights
things
my
such as
point.
that. Yeah.
Exactly. Yes. So okay. And just as a final note too, there's on a scale, if you will. I think traditionally you have maybe more options on the corporate side to play with, tools to play with, if you will, as opposed to on the limited liability company side. And
I get it.
It's into some very esoteric tax issues, but with LLCs, I find in my practice and experience that it really kind of boils down to working with profits interests.
There are, again, as I said earlier, I mean, you can do mostly everything you want with an LLC. Certainly profits interest, which is a whole other means of compensation,
Right.
Is an issue or something to consider. But, there are options pools available, even under an LLC umbrella, although they're not shares, they're units. It's terminology difference between an LLC and a C corporation. But nonetheless, and to your point is, those that come along later obviously would be compensated at what would be a reasonable rate or a reasonable amount of ownership at that stage versus, the early founders.
And I'm just going to close on this topic with that taxation plays a huge part in this area, which is, again, just one of the reasons why you really need to work with a professional in putting together these plans. Next, we're down to 2 more topics, and we have 2 more minutes.
I think we are out of time.
Are we?
Okay.
For now. We did have a question about resources on a number of topics that you touched on, so I think it would be really fantastic if we could compile some of the resources that you guys, on the topics that you were discussing, and put them, either on our website or we'll shoot it out to our attendees. That would be really fantastic.
Sure.
So I thought that was incredibly insightful. It's incredibly complex, company formation, what to consider. So thank you all for sharing your insights. And I just ask, to close out this session, if you could just give one final piece of advice to people who have considered or are considering forming or have a really early company, what they need to do.
Start off.
Sure, Joe, we'll go in reverse order.
Okay. I mean, since I really spoke on the IP portion, and as we discussed, we kind of got into sort of the internal users, internal IP considerations. One other thing to consider is, if you're bringing in an IP from outside, or you're concerned about other ownership, we didn't really get into freedom to operate opinions. We just touched on clearance search a little bit. That's another thing to keep in mind. But the thing it always comes back to for me from an IP perspective is secrecy. Keep it confidential. get something on file before you start telling anybody. Get your IP set up with your university before or as soon as possible, so everything is squared away and move on from there. And good luck.
Good luck is always a good thing. I think that several of the topics we touched on are really important when you're considering starting that venture. I always suggest good advice, get the legal opinion, get the financial or accounting opinions that you need. Again, I'm sure in most venues or most urban areas like Philadelphia, you've got major law firms that do have some programs where they do work with early stage companies, and they'll give a little bit of free time or a little bit of advice. Take advantage of it, find out who those firms are in your region, your area, and take advantage of that. And just anecdotally, a real quick one, licensing agreements, because at the university, at the tech level, you're going to see a lot of licensing agreements. Make sure that they're buttoned up. And I'm not talking about necessarily on just the university or the tech transfer side of it, but on the other side, if you should become a licensee, make sure that you've got a solid agreement. I just went through a situation with a company with really not high tech, but where the licensor decided they wanted to get out of a licensing agreement coming up for renewal, but the licensee had the right of renewal, but they instituted a lawsuit. And bottom line is the licensing agreement was not definitive enough. And so what should have been a simple matter wound up being settled for $3,000 after $50,000 of legal fees. You don't want to get into those situations. Once again, if you're going to do that, make sure that the document is well written and that it protects you, but also protects both parties.
Well, and you stole a little bit of my thunder, but I'll end with what I started with, which is none of this stuff, none of these areas are self-help areas. You really, you're only asking for problems by doing so. And I know there's a lot out on the web that offers sort of cheap legal advice, if you will, on doing some of this stuff. My advice is find a competent professional to work with, and I work with early stage entrepreneurial clients all the time. And as Harvey alluded to, I like to think I'm pretty flexible with my time and my engagement. I recognize that, in many respects, I'm making investment in accommodating. I wouldn't shy away from seeking a professional because of the fear of cost. Because I do think that for those who work in this arena, we understand the challenges, and so where I can be flexible, I'm certainly willing to accommodate.
Thank you.
Thank you.
Once again.
Thank you.
This is BioStrategy Partners, and if you'd like to learn more about our programs and services or learn more about our upcoming events, please visit us on our website or connect with us on LinkedIn and other social media.